This is the Small Claims Court. What is the Small Claims Court? In England and Wales, there is no such thing as the Small Claims Court. The Small Claims Court, as we know it, is when a claim is started in the county court and, after a defence has been filed, the claim is allocated to a track known as the Small Claims Track. Currently, there are 3 different tracks in the county court. Small claims, which are for non-complex claims up to £10,000 or £1,000 if it's a personal injury or housing disrepair matter, and the fast track and multi-track, which are for claims up to £25,000 or above £25,000 respectively. And until at least the end of 2020, there is also a process known as the European Small Claims Procedure. How to start a small claim. There are 3 methods to starting a claim in England and Wales. Money claim online, the county court online, and the good old-fashioned paper method, which is my preference. The county court online is a new system that is being brought in to replace money claim online, and is currently in testing for people who are acting without solicitors. A select number of solicitors have been invited to trial the county court online as well. Money claim online is not user friendly due to the lack of space to put in full details of the case. If you see money claim online, for your details of the claim you only have just over 1,000 characters. With some more complex claims, the space can be taken up quite quickly, and a failure to include full details of the case can be a breach of court rules. Contrast to that, the county court online is more user friendly. There is an unlimited amount of space to put in details of the case, as well as space to list the evidence that you have to support your claim, and to put in details of a chronology as well, which is very helpful. In both cases, both MCOL and the county court online have a discount on court fees, which in higher value claims can be significant. A good advantage of both these types of system is that the claim is started immediately. The claim is issued, automatically served by post, and for the county court online by email, and the time period for a defendant to respond starts almost immediately. The good old-fashioned paper method is fully compliant with all the rules, provided you draft the documents correctly and in accordance with the rules. However, a disadvantage is that the court fees are higher. For example, a claim worth £10,000 using the paper method, the issue fee is £500, where if you use the online methods, the issue fee is £450. You also have to wait for post to be delivered. Of course, there's delays at the moment, potentially with COVID-19. You have to send the claim form and particulars of claim in the post, wait for it to come back, and the time period eventually starts at some point in the future. The small claims track procedure is quite unique, as some of the civil procedure rules or the court rules do not apply. The court rules that don't apply include disclosure and inspection, most of the rules of evidence, some aspects of expert evidence, Part 36 offers, and the majority of Part 39 relating to hearings. This means that this procedure is more flexible and also results in quicker resolution of claims. As can be seen, parties exchange evidence and documents normally 14 days before the hearing, which is different to what happens in the fast track and multi track, where documents are exchanged, then evidence, and then you have a long wait for the trial. Hearings take place informally, normally in a judge's chambers, but given the lack of judge's chambers in a courtroom, where it is normally informal, and attendance at hearings is optional in the small claims track, provided that the rules of giving notice are complied with. The rules on representation in small claims are also flexible, which means that you can have any person representing you at a small claim, whether it's family or friends, a man off the street, someone that you work with, anyone. There is law that allows any person in a small claim to represent any party, provided conditions are met. Those conditions is that the party must also attend the hearing. Ideally, in small claims, you do not need a lawyer, because the hearings are informal. Judges will assist litigants in person in dealing with their claim and will effectively run the hearing so a fair and just outcome is achieved. However, it's always good having a lawyer there, because they can fight the case for you with no emotional involvement which may hamper your arguments. Also, in the small claims, costs are limited to nominal fixed costs, court fees, travel expenses, loss of earnings and expert fees, except in cases where the court finds a party has acted unreasonably. So instead of racking up a load of hours doing work and getting paid for it, the small claims track essentially means that you can't recover those costs, apart from in the exception where a party has acted unreasonably. I mentioned earlier optional hearing attendance, but of course the big negative, big risk of not attending is that you may lose the case. But if you can't attend or don't want to attend, then the court can still deal with the case based on the papers, provided that you give notice to the court in writing at least 7 days before the hearing. You give notice to the other party at least 7 days before the hearing in writing, and you have sent all documents to the other party that you've sent to the court at least 7 days before the hearing. And vital in the notice that you give to the court and the other party is that you must confirm that you've complied. If you don't comply and don't attend, then the court can deal with the case in your absence, and the court may disregard any written evidence or documents that you submitted. If you have complied and still don't attend, then there's the risk that you still may lose, because anything that the judge says or anything that the other party may say, you can't fight against because you're not there to do that. Advantage of not attending is that you save the cost of going. You might be in work, you might lose earnings, especially if you're in a job that pays more than £95 per day. You might not, you might as well just stay in work. Dealing with costs, if you win, you may be able to recover costs. I say may because costs are always at the discretion of the court. There is no guarantee. But the fixed costs are between £50 and £100. Normally these are reserved for legal representation, if you have one, but in certain circumstances a litigant in person can recover the fixed costs. You also recover the court fees that you paid. Normally that's guaranteed. However, there are instances where it's not, and that's in cases where unreasonable behaviour is evident despite you winning the case. You can also claim expenses for travelling to and from the hearing, petrol, parking, travel expenses, etc. You can also claim loss of earnings for attending the hearing, but only up to £95. Ideally you should bring evidence to the hearing of your loss of earnings, but from my experience, judges basically ask you what do you earn salary wise, and then it's worked out. They'll normally take your word for it. Do bring your evidence just in case. Wage slips, contract of employment, that sort of thing. If you're self-employed, tax returns or any other records. If there is an expert witness involved in the case, you can recover up to £750 for the expert's fees. The rules do not make clear whether that includes VAT or not. Some judges do allow VAT on top, some judges don't. And the normal rule is that the loser pays the winner's costs. It is a normal rule, and there can be exceptions, and that's up to the court to decide on the day. For example, unreasonable behaviour. If you win but you have acted unreasonably, then the court do have a discretion to say you're not entitled to any costs. Moving on to the exception of the normal rule. Unreasonable behaviour. If you win and the other party has behaved unreasonably, then the court can award more costs above those that are in the normal rules. So for example, this includes lawyer fees, the costs of a representation, a barrister or a solicitor or other lawyer attending, or even your hourly rate or other expenses for loss of time whilst representing yourself. Two brilliant examples of this I've had in courts. One in Birmingham County Court, where I represented a company against a litigant in person, and the litigant in person failed to comply with the court order to provide documents and evidence. The court struck out the claim and awarded my client his time and my fees. Another case was against EasyJet in a flight delay claim, where EasyJet defended the claim fully. However, their defence was incorrect. They had stated the wrong time of the flight on their documentation, and they maintained that their defence was true, despite me pointing it out to them that it was false. I pointed it out all the way to a final hearing in writing. I presented the judge with all of my written correspondence to tell them that they've got it wrong, and the judge found I did get it wrong. My client won. He got his compensation for his delayed flight, and my firm of solicitors that I was working for recovered £2,500 costs, all for a €250 flight. So the rules are there, they can assist. Unreasonable behaviour does exist, but it is very rare. It is a high test to overcome. Those two cases are the only two cases I've had in 5 years. I mentioned at the beginning the European Small Claims Procedure. This is still available in England and Wales until at least the end of 2020, when we finally leave the EU, the end of the transition period. It still applies in Scotland as well, and Northern Ireland, again until the end of 2020. And this may be useful for those people who may be watching this in Scotland or Northern Ireland. The European Small Claims Procedure is for cross-border disputes. So, unfortunately, cross-border disputes. So England versus someone in Scotland, someone in England versus someone in Ireland, someone in England versus someone in France. These work best, I've seen, for flight delay claims, especially against cases against Ryanair, but it can work for any cross-border dispute. You know, if there's a Scottish claimant and an English defendant, the European Small Claims Procedure works there as well. The claim can be made in the country you're in or in the country of your opponent. An example we've done a lot recently is claims against Ryanair. We've started the claim in Ireland instead of England and Wales. There are some advantages to that, which I'll share later. And the claim value must be no more than €5,000. That's the limit on European small claims, so it's different to the English system, where the limit is £10,000. There is no online issue, so everything should be done by post, but you have to speak to the court that you're issuing at to see if they will accept papers by email. If you want to start the claim in England and Wales, the court fee is the same as the normal small claim court fees. But if you start in another country, then you pay the court fees that apply in that country. So, for cases we've started in Ireland, the court fee to start a small claim under the European procedure is €25, much cheaper than starting it in England. And for claims started in England and Wales, all of the normal small claim rules apply except costs. Costs in the European Small Claims Procedure are not limited to fixed costs. They can be claimed at an hourly rate. So if you're a litigant person and have spent time working on the case, then you can claim your £19 per hour or your financial loss. If you're using a lawyer, the lawyer can recover their legal costs at the hourly rate. And if there's any hearings, you can also claim the costs of representation. The only limit on costs is that they must be proportionate to the value of the claim. Proportionality is a test which is a kind of an objective test. You know, have you spent a reasonable sum in comparison to the value of the claim? That's what the European rules say, but each country has their own proportionality rules. England and Wales has complex rules on proportionality, not just based on the value. You can start a European small claim by using Form A. You can get it online. It's about 7 or 8 pages long, unfortunately, but it's a lot of tick boxing and filling in bits of information. It is helpful to include some sort of statement or particulars of claim to go with it, because the Form A doesn't have that detail on it. The Form A simply has the names of the parties, which court, the amount of money you're claiming, the amount of interest, and a brief detail of what the claim is about. Like I said, there's no online issue, so it must be sent by post to the court that you're issuing at. You can check with the court whether they accept it by email. We know at the current time that the Dublin courts do accept by email, and they accept payment by bank transfer. In England they don't accept it by email at the moment, and you have to send a cheque or provide card details or other method of payment. The process is similar to England and Wales small claim. A apart from the fact that your opponent has 30 days to reply instead of 14 days. And within 30 days of the reply, the court must either give a judgment, which in essence means that your claim could be settled within 60 days, which is different to England and Wales, which could take 9 months. The court could also request further details, or they could require the parties to attend the hearing, as there is an option on the form to start the claim to say whether you want a hearing or not. And once the claim has been settled via the European Small Claims Procedure, you can obtain a certificate of judgment, which can be enforced anywhere in Europe. So that's the European Small Claims Procedure. And that is the Small Claims Procedure overall. If you need any more information, please contact us. You can visit our website. You can also make appointments with us for free initial consultations. Please feel free to follow us and like us on Facebook and Twitter, and check out our testimonials on Trustpilot. Do stay tuned for more presentations, or subscribe.